Question 1. A California notary public is authorized to certify copies of which of the following documents? A. Birth certificates. B. Marriage licenses. C. Powers of attorney. D. Any document recorded in the public records. Answer: C. Powers of attorney. A California notary public can only certify copies of certain documents, primarily a power of attorney under specific conditions, or a copy of a notary's own journal entries. State law generally prohibits notaries from certifying copies of vital records like birth or marriage certificates, as these are typically obtained from the issuing government agency. The restriction exists to prevent fraud and ensure the authenticity of such critical documents. Always remember that a notary's authority to certify copies is very limited and specific, so be sure to know which documents are permitted. Question 2. In most U.S. jurisdictions, what is the primary purpose of a notary public journal? A. To serve as proof of identity for the signer. B. To record every notarial act performed by the notary. C. To track the notary's income and expenses. D. To list all the documents signed by the notary. Answer: B. To record every notarial act performed by the notary. The primary purpose of a notary journal is to create a secure, chronological record of every notarial act performed, ensuring accountability and deterring fraud. This record typically includes details such as the date and time, type of act, document title, signer's name, and method of identification used. Maintaining a diligent and complete journal protects both the public and the notary by providing a clear audit trail of services rendered. Think of your journal as a crucial logbook that proves your notarial duties were performed correctly and legally. Question 3. What is the maximum fee a California notary public may charge for taking an acknowledgment? A. $10 per signature. B. $15 per signature. C. $20 per signature. D. The fee is set by the county in which the notary operates. Answer: B. $15 per signature. For an acknowledgment, a California notary public is permitted to charge a maximum fee of $15 per signature acknowledged. This fee is stipulated by state law to ensure consistency and prevent excessive charges for notarial services. It is crucial for notaries to be aware of and adhere to these statutory fee limits, as overcharging can lead to disciplinary action. Always post your fees clearly and be transparent with clients about the cost of services before performing the notarial act. Question 4. If a signer presents a document with a missing signature line for the principal, what should the notary do? A. Insert a signature line and proceed with the notarization. B. Advise the signer to add a signature line and sign, then proceed. C. Refuse to notarize until the document is properly prepared by the signer or their representative. D. Notarize the document as is, assuming the signer knows where to sign later. Answer: C. Refuse to notarize until the document is properly prepared by the signer or their representative. A notary public's role is to verify signatures and administer oaths, not to prepare or alter documents. If a document lacks a necessary signature line, the notary must refuse to notarize it until the signer or the document preparer properly completes or corrects the instrument. Proceeding with notarization on an incomplete or improperly formatted document could constitute the unauthorized practice of law or create legal issues for the signer. Remember, notaries verify what is on the page, not what should be on the page, so the document must be complete before you begin. Question 5. What type of identification is generally considered the most reliable for a notary public to accept from a signer? A. A credit card with a photo. B. A U.S. driver's license or state-issued identification card. C. A student ID card from a local university. D. A foreign passport that is not current. Answer: B. A U.S. driver's license or state-issued identification card. A U.S. driver's license or state-issued identification card is widely considered the most reliable form of identification because it is issued by a government agency, contains a photograph, physical description, and signature of the bearer, and is typically equipped with security features. Notaries are required to use satisfactory evidence of identity, and government-issued IDs are typically the preferred method. Always inspect identification carefully for alterations or expiration dates to ensure its validity and protect against fraud. Question 6. When performing a jurat, what key element differentiates it from an acknowledgment? A. The signer must personally appear before the notary. B. The notary must verify the signer's identity. C. The signer must swear or affirm to the truthfulness of the document's contents. D. The notary must witness the signing of the document. Answer: C. The signer must swear or affirm to the truthfulness of the document's contents. The defining characteristic of a jurat is that the signer must swear or affirm under oath or affirmation that the statements in the document are true. In contrast, an acknowledgment simply verifies that the signer willingly signed the document. For a jurat, the notary must administer an oath or affirmation to the signer and witness the signing, ensuring the signer understands the solemnity and legal implications of their declaration. Always remember, an oath for a jurat, no oath for an acknowledgment. Question 7. A California Notary Public's commission is valid for how many years? A. 2 years. B. 3 years. C. 4 years. D. 5 years. Answer: C. 4 years. A California Notary Public Commission is valid for a period of 4 years from its effective date. This fixed term ensures that notaries regularly refresh their understanding of laws and procedures through renewal processes and continuing education. Keeping track of your commission's expiration date is crucial to avoid any lapse in your authority to perform notarial acts. Plan ahead for renewal to maintain continuous eligibility. Question 8. What must a notary public do if a signer refuses to provide satisfactory identification? A. Proceed with the notarization and note the refusal in the journal. B. Accept an expired ID if it looks like the signer. C. Refuse to perform the notarial act. D. Allow the signer to use a credible witness they brought with them, regardless of the notary's knowledge of the witness. Answer: C. Refuse to perform the notarial act. A notary public is legally required to obtain satisfactory evidence of a signer's identity before performing a notarial act. If a signer refuses or is unable to provide acceptable identification, the notary must decline to perform the notarization. This rule is fundamental to preventing fraud and ensuring the integrity of the notarial process. No ID, no notarization, it's a critical safeguard for everyone involved. Question 9. What is a key responsibility of a notary signing agent, NSA, that goes beyond the duties of a general notary public? A. Administering oaths and affirmations. B. Verifying the identity of signers. C. Guiding borrowers through complex loan documents at real estate closings. D. Certifying copies of vital records. Answer: C. Guiding borrowers through complex loan documents at real estate closings. A notary signing agent, NSA, specializes in handling loan document signings for real estate transactions, which involves presenting and explaining the various documents to the borrower. While an NSA still performs general notarial acts like acknowledgments and jurats, their unique role involves navigating the specific nuances of loan packages, ensuring all signatures are properly obtained and notarized, and returning the documents promptly. NSAs serve as a crucial link in the mortgage closing process, so understanding loan documents is essential for this specialization. Question 10. If a California notary public moves to a new county within California, what action must they take? A. No action is required, the commission is statewide. B. Notify the Secretary of State within 30 days of the new business or residence address. C. Apply for a new commission in the new county. D. Pay a transfer fee to the Secretary of State. Answer: B. Notify the Secretary of State within 30 days of the new business or residence address. A California notary public must notify the Secretary of State by certified mail or other means prescribed by the Secretary of State within 30 days of any change of business or residence address, even if moving to a different county within the state. While a California Notary Commission is statewide, maintaining current address information on file is a legal requirement to ensure the Secretary of State can contact the notary and for official records. Prompt notification helps you remain in compliance with state regulations. Question 11. What is the primary purpose of a notary public bond? A. To protect the notary from legal liability. B. To cover the notary's administrative costs. C. To protect the public from financial damages caused by notary misconduct. D. To serve as an investment fund for the notary. Answer: C. To protect the public from financial damages caused by notary misconduct. A notary public bond is a financial guarantee required by the state to protect the public from any financial damages resulting from a notary's negligence or misconduct. If a notary causes financial harm through their official acts, the injured party can make a claim against the bond to recover losses. The bond does not protect the notary directly, but rather offers a layer of protection for the public. Always remember that the bond is for the public's benefit, not the notary's personal protection. Question 12. Can a notary public notarize a document for their spouse? A. Yes, always. B. No, never. C. Only if the spouse is not receiving a direct financial or beneficial interest from the document. D. Only if the notary is an attorney. Answer: C. Only if the spouse is not receiving a direct financial or beneficial interest from the document. A notary public must not perform any notarial act if they have a direct financial or beneficial interest in the transaction. This includes situations where the signer is a spouse, domestic partner, or close relative, and that person benefits directly from the document. The prohibition aims to prevent conflicts of interest and maintain impartiality, ensuring the integrity of the notarial act. If your spouse is merely a witness and has no personal interest, it might be permissible, but generally, it's best to avoid notarizing for immediate family members to prevent even the appearance of impropriety. Question 13. What is the typical appearance of a notary public's official seal or stamp? A. It must be a raised, embossed seal. B. It must be an ink stamp. C. It can be either an embosser or an ink stamp, but an ink stamp is generally preferred. D. It must include the notary's signature. Answer: C. It can be either an embosser or an ink stamp, but an ink stamp is generally preferred. While some jurisdictions allow an embosser, an ink stamp is generally preferred and often required because its impression is clearer and more reproducible, especially for photocopying or scanning. The seal must contain specific information, such as the notary's name, commission number, county of principal place of business, and expiration date of the commission. Always ensure your seal is legible and contains all required information, as a clear impression is critical for document acceptance. Question 14. Which of the following is a fundamental principle of notarial practice? A. A notary may give legal advice if asked by the signer. B. A notary must personally witness the signing of every document. C. A notary must always be impartial and avoid conflicts of interest. D. A notary is responsible for verifying the truthfulness of the document's content. Answer: C. A notary must always be impartial and avoid conflicts of interest. Impartiality is a cornerstone of the notary's role, meaning a notary must act as a neutral third party and avoid any situation that presents a conflict of interest. This ensures that the notarial act is performed without bias or personal gain. A notary must never offer legal advice, determine the truthfulness of a document's content, only the signer's identity and willingness to sign, or automatically assume they must witness every signature, only for jurats or signature witnessing. Maintaining strict neutrality is crucial to upholding public trust in the notarial system. Question 15. If a document requires a jurat, but the signer is unwilling to take an oath or affirmation, what should the notary do? A. Change the notarial certificate to an acknowledgment. B. Administer a modified oath without the religious component. C. Refuse to perform the notarial act. D. Have the signer sign a separate statement affirming their truthfulness. Answer: C. Refuse to perform the notarial act. If a document specifically requires a jurat, the signer's willingness to take an oath or affirmation is a mandatory element of the notarial act. Without the signer's solemn declaration, the notary cannot complete a jurat. The notary must therefore refuse to perform the notarial act, as altering the certificate or proceeding without the oath would violate notarial law and compromise the integrity of the document. The integrity of the notarial act depends on fulfilling all statutory requirements for the specified certificate type. Question 16. What is the maximum fee a California notary public may charge for administering an oath or affirmation? A. $5 per person. B. $10 per person. C. $15 per person. D. No fee may be charged for administering an oath or affirmation. Answer: C. $15 per person. In California, the maximum fee a notary public can charge for administering an oath or affirmation is $15 per person, similar to the fee for taking an acknowledgment. This fee applies whether the oath is for a jurat, a deposition, or any other official sworn statement. It's important for notaries to maintain a clear and consistent fee schedule, always abiding by the maximum amount set by state law to ensure fair practice. Question 17. Which of the following statements regarding the advertising of notarial services is generally true? A. Notaries may advertise as notario publico if they are fluent in Spanish. B. Notaries may advertise legal advice if they have some legal training. C. Notaries must clearly state they are not attorneys and cannot give legal advice if advertising in a non-English language. D. Notaries are prohibited from advertising their services. Answer: C. Notaries must clearly state they are not attorneys and cannot give legal advice if advertising in a non-English language. Many states, including California, have specific regulations concerning advertising by notaries, particularly in languages other than English. To prevent consumer deception, especially among immigrant communities who might confuse notary public with the broader role of a notario publico, which often implies legal expertise in other countries, notaries must clearly state that they are not attorneys and cannot provide legal advice. This crucial disclosure protects the public from unauthorized practice of law. Always be transparent about your limitations and clearly state you are not an attorney. Question 18. What action must a notary public take if their notary seal is lost or stolen? A. Immediately obtain a new seal and continue notarizing. B. Notify the Secretary of State or commissioning authority and local law enforcement immediately. C. Publicly post a notice about the lost seal. D. Suspend all notarial acts for 30 days. Answer: B. Notify the Secretary of State or commissioning authority and local law enforcement immediately. If a notary's seal is lost or stolen, it is imperative to immediately notify the Secretary of State, or relevant commissioning authority, and local law enforcement. This prompt notification is crucial to prevent unauthorized use of the seal for fraudulent purposes. Failing to report a lost or stolen seal could lead to the notary being held liable for any damages caused by its misuse. Protecting your seal is a vital responsibility, as its misuse could have serious consequences. Question 19. A signer requests that the notary perform a remote online notarization, RON. In which of the following states is RON typically permitted for general notarizations? A. California. B. Illinois. C. New Jersey. D. New York. Answer: B. Illinois. As of current regulations, Illinois is one of the states that has enacted comprehensive legislation permitting permanent remote online notarization, RON, for general notarial acts. States like California and New York have not yet authorized permanent RON for all notarial acts, though temporary measures were sometimes in place during emergencies. Each state has its own specific laws regarding RON, so it's critical for notaries to know the precise regulations of their commissioning state before attempting any remote notarial act. Question 20. Before performing any notarial act, a notary public must always ensure: A. The signer fully understands the legal implications of the document. B. The document is free of errors or omissions. C. The signer personally appears before the notary. D. The notary agrees with the content of the document. Answer: C. The signer personally appears before the notary. Personal appearance of the signer before the notary is a cornerstone requirement for almost all traditional notarial acts across U.S. jurisdictions. This allows the notary to verify the signer's identity, observe their demeanor, and administer any necessary oaths or affirmations directly. Without personal appearance, the notary cannot adequately fulfill their duty to prevent fraud. Remember, face-to-face interaction is generally non-negotiable for a valid notarization. Question 21. What is the minimum age requirement to become a notary public in most U.S. jurisdictions, including California? A. 18 years old. B. 21 years old. C. 25 years old. D. 30 years old. Answer: A. 18 years old. To be eligible for a notary public commission in most U.S. jurisdictions, including California, an applicant must be at least 18 years of age. This minimum age requirement ensures that notaries are considered adults with the legal capacity to understand and fulfill the responsibilities of the office. Meeting this age criterion is one of the fundamental prerequisites for applying for a commission. Question 22. A notary public receives a document that contains blanks. What is the notary's appropriate action? A. Fill in the blanks according to the signer's instructions. B. Refuse to notarize the document until all blanks are filled in or crossed out. C. Notarize the document and write blanks present in the journal entry. D. Advise the signer to fill in the blanks later. Answer: B. Refuse to notarize the document until all blanks are filled in or crossed out. A notary public should not notarize a document that contains blank spaces, as this could facilitate fraud or unauthorized alterations after notarization. The notary's duty is to certify signatures on complete documents. The signer must either fill in the blanks or, if they are intentionally left blank, cross them out and initial them before the notarial act takes place. This practice safeguards the integrity of the document and protects all parties involved. Question 23. What is the required education for a new notary public applicant in California? A. No education is required, only an exam. B. A 3-hour notary education course. C. A 6-hour notary education course. D. A 12-hour notary education course. Answer: C. A 6-hour notary education course. All new notary public applicants in California are required to complete a minimum of 6 hours of approved notary public education. This comprehensive training ensures that aspiring notaries are well versed in the laws, regulations, and best practices governing their duties. Completing this educational requirement is a vital step toward becoming a commissioned notary and demonstrating a foundational understanding of the role. Question 24. A notary public is presented with a document written entirely in a foreign language they do not understand. Can they proceed with the notarization? A. Yes, as long as the signer understands the document. B. No, the notary must understand the language of the document. C. Only if an interpreter is present and sworn in. D. Yes, as long as the notarial certificate is in English. Answer: D. Yes, as long as the notarial certificate is in English. A notary public is not required to understand the content of a document written in a foreign language, provided the notarial certificate itself is in English and the notary can properly identify the signer and perform the notarial act. The notary's role is to verify the signature and identity of the signer, not to interpret or validate the document's content. Therefore, if the notarial certificate is in a language the notary understands, they can proceed, as their duty pertains to the act of signing and identity, not the document's subject matter. Question 25. Which of the following is a prohibited act for a notary public in nearly all U.S. jurisdictions? A. Charging a fee for notarial services. B. Certifying a copy of a birth certificate. C. Administering an oath to a deponent. D. Notarizing a document for an elderly person. Answer: B. Certifying a copy of a birth certificate. In nearly all U.S. jurisdictions, a notary public is prohibited from certifying copies of vital records such as birth certificates, death certificates, or marriage licenses. These documents are generally only certifiable by the issuing government agency to maintain their authenticity and prevent fraud. Notaries must decline such requests, as their authority to certify copies is very limited and specific, usually confined to certain types of documents like powers of attorney or their own journal entries, depending on state law.